Imagine, if you will, you are going to prosecute a former president. You know it's going to be contentious, unpopular even. It's going to be a knockdown, drag-out fight. So of course, you're going to be as careful as possible. You take every possible step to avoid conflicts of interest because you know that you're going to be under a microscope. Well, you, my friend, are not Fulton County District Attorney Fani Willis, who apparently did none of those things. Our resident prosecutor Spencer the Scowl Owl will unpack this entire cluster debacle and explain how it turned into a giant soap opera.
Like sands through the hourglass, so are days of our lives. Fulton County edition. The legal soap opera whose writers jumped the shark 2 seasons ago. It's like Lost and Suits got together and made a terrible, ugly baby. You've got sex, money, power, betrayal, and vengeance. Allegedly. Let's remind ourselves of the cast of characters. Fulton County District Attorney Fani Willis, elected in November 2020 and serving since January of 2021, and for what it's worth, running for re-election in November 2024. Nathan Wade, one of 3 special prosecutors Willis hired in November 2021 to handle the Trump election fraud RICO case. And former lover of Fani Willis, Terrence Bradley, an attorney and former law partner with Nathan Wade, who represented Wade in Wade's divorce proceedings, but who also separated from his legal partnership with Wade after an allegation of sexual harassment. Michael Roman, one of the RICO defendants and former director of Election Day operations for the Trump 2020 campaign. Ashley Merchant, defense attorney for Michael Roman and friend and confidant of Terrence Bradley. Robin Yurdy, a former friend of Willis's who was essentially told she had to resign from the DA's office or would be fired for unspecified reasons. Donald Trump.
I get along with everybody.
And finally, Scott McAfee, the judge presiding over the RICO case and lover of his wife, probably? I mean, he seems pretty normal. Oh, and there are a ton more. Supporting cast. Through his lawyers, Michael Roman alleged that Willis had a romantic relationship with Wade and hired Wade in an elaborate kickback scheme to enrich herself. Roman filed a motion to disqualify Willis, her office, and the Fulton County District Attorney's Office from further prosecuting this matter. The motion also sought dismissal of the indictment, but that was like the Hail Mary that really only had a chance if the evidence developed extremely favorably. Trump's lawyers and other defendants joined the motion and added to it, threatening to derail the entire Fulton County case. The motion to disqualify accused Willis of violating laws prohibiting conflicts of interest and nepotism. At the time the motion was filed, the facts about the relationship between Willis and Wade were sparse. Before Nathan Wade was appointed as special prosecutor, he had never led a high-profile criminal case and had largely worked as a suburban defense lawyer and municipal judge. But Wade was paid well over $500,000 for his work as special prosecutor. And then the bombshell allegation that Wade and Willis were lovers, and he spent some of the money he earned on Willis, taking her for lavish dinners and vacations. In other words, a kickback scheme. The allegations came to light after Wade filed for divorce. When his wife started the process of uncovering his assets, Wade ignored discovery orders and was held in contempt of court. Oh, and by the way, Wade filed for divorce the day after he started working as a special prosecutor for Fulton County. Willis didn't deny having a relationship with Wade. Instead, she went to a historically black church and gave a speech decrying the inquiry as racist.
I appointed 3 special counsel, as is my right to do, paid them all the same hourly rate. They only attacked one. I hired one white woman, a good personal friend and great lawyer. A superstar, I tell you. I hired one white man, brilliant, my friend, and a great lawyer. And I hired one black man, another superstar, a great friend, and a great lawyer.
She noted that the other 2 special prosecutors, who were white, weren't subjected to any scrutiny. Eventually, Judge McAfee held an evidentiary hearing over multiple days, and boy, was it something. Wade testified that he met Willis in 2019 at a conference, and they became friends. His romantic relationship with Willis started after his appointment as special prosecutor sometime in early 2022. He testified that when he went on trips with Willis, he would pay with his card because she was concerned about her safety, but that she would reimburse him for her portion in cash. He also testified that he wasn't dating anyone in 2020 because he was focused on a cancer diagnosis. Yet Wade's credibility took a pretty big hit. He was questioned about his answers to interrogatories filed as part of his ongoing divorce case. A May 2023 interrogatory asked Wade to disclose any sexual relations he had during his marriage, including during the time of separation and up to the present. He responded, none. Another interrogatory asked Wade to identify any and all occasions in which he entertained a member of the opposite sex from date of marriage to the present. Wade again answered, none.
When did your romantic relationship with Miss Willis begin?
2022.
When in 2022?
Early 2022.
Both answers were, of course, utterly false. Wade tried to explain that his marriage was irretrievably broken in 2015, and so he didn't consider anything after 2015 to be during his marriage, despite the fact that he was still legally married, and the interrogatories clearly stated from the date of marriage to the present. The law has a technical term for this. Willis's testimony about the relationship largely tracked Wade's. When questioned about her reliance on cash, she explained that she always has cash on hand in her house. She said her father taught her to always have at least 6 months of cash around at all times, and to always have $200 in your pocket on a date, so that if a man acts up, you can go where you want to go.
When you meet my father, he's going to tell you as a woman, you should always have, which I don't have, so let's don't tell him that. You should have at least 6 months in cash at your house at all times. If you're a woman and you go on a date with a man, you better have $200 in your pocket, so if that man acts up, you can go where you want to go. So I keep cash in my house.
And Willis testified that her relationship with Wade ended in the summer of 2023, not because of the prosecution, but because they had different views on gender equality.
Mr. Wade is used to women that, as he told me one time, the only thing a woman can do for him is make him a sandwich.
John Floyd, Willis's father, largely corroborated Willis's testimony, both about the cash and about the timing of the relationship with Wade.
Your Honor, I'm not trying to be racist, okay? But it's a black thing, okay? You know, I was trained, and most black folks, they hide cash or they keep cash.
He testified that he didn't meet Wade until 2023, but that he did meet the boyfriend Willis dated in 2019 and 2020, who frequently visited the home Floyd shared with Willis at the time. He was a disc jockey or something, and Floyd nicknamed him Deuce. According to Floyd, Wade was never at the house during the period that Floyd lived with Willis from 2019 to 2021, unlike Deuce. Then came Robin Yeardy, the former friend. Yeardy testified that she and Willis met in college and became good friends for many years. Following Willis's election in 2020, Yeardy accepted a non-attorney position at the DA's office. Yeardy agreed that Willis and Wade met at a 2019 judicial conference, but according to her, they began a romantic relationship shortly thereafter. Yeardy testified that Willis told her about a romantic relationship with Wade prior to Wade's appointment as special prosecutor. Yeardy also said that she had no doubt in her mind that Wade and Willis were in a romantic relationship from 2019 to 2022.
And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
And Yeardy said that prior to Willis's election, she observed Wade and Willis hugging, kissing, and being affectionate with one another. Yet on cross-examination, Yeardy inexplicably couldn't remember details about what Willis said and when. Even worse, Yeardy acknowledged that she was let go from the DA's office under a cloud.
The situation happened. That wasn't my fault. And I either was going to resign or be let go.
According to Yeardy, the circumstances under which she left the district attorney's office ended her friendship with Willis, and the two haven't spoken since. Finally, Terrence Bradley. Oh, Terrence. Bradley testified that he first developed an attorney-client relationship with Wade in 2018. Around that time, Wade approached Bradley for legal advice as he considered filing for divorce from his estranged wife, although Wade didn't ultimately file for divorce until 2021. Bradley then cited attorney-client privilege, saying he possessed no non-privileged personal knowledge related to Willis and Wade's romantic relationship. Both Wade's personal attorney and the DA's office repeatedly invoked the attorney-client privilege to prevent Bradley from answering further questions. Yet Ashley Merchant was able to cross-examine Bradley on some damning text messages and emails. Merchant texted Bradley, "On information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. Is that accurate? Bradley responded, no, it was municipal court. Well, regardless of whether it was a magistrate or municipal judgeship, that sure seems to imply that the romantic relationship started before Willis was DA, in other words, before November 2020. Merchant also had an email that she sent Bradley just days before she filed her initial motion to disqualify, which alleged that Willis and Wade were involved prior to his appointment as a special prosecutor on November 1st, 2021. Her email to Bradley included a copy of the motion that she ultimately filed. Bradley responded, "Looks good." And what makes this all the worse, at the beginning of his testimony, Bradley testified that he never directly communicated with Merchant about Willis and Wade's relationship. Ugh. Does it get worse for Bradley? Oh, yes, sir. Bradley was previously Wade's law partner. On direct examination, Bradley said he left the partnership because he wanted to leave and go out on my own. But he also admitted that he had a disagreement with Wade. He refused to go into the specifics about that disagreement, though, saying it was privileged as it related to his representation of Wade in the divorce case. On cross-examination, however, Bradley admitted that an employee of the firm accused him of sexual harassment, and as a result of that allegation, he left the firm.
Mr. Wade brought to your attention the sexual assault allegations that you've been asked about by the prosecutor, correct?
Correct.
And at that time that Mr. Wade brought those allegations to your attention, you were still the attorney for Mr. Wade, correct?
Correct.
And therefore, your conduct as an attorney and the attorney at that time for Mr. Wade was called into question by Mr. Wade's passing along to you allegations of misconduct, correct?
After all the evidence was heard, Judge McAfee heard closing arguments. The defendant settled more or less on three bases for disqualification. One, Willis's personal financial conflict of interest in hiring Wade and then getting financial benefits in return. Two, the speech at the church. And three, Willis's conduct in defending against the motion to disqualify, including alleged perjury on the parts of Willis and Wade. Did it end there? No. After closing arguments, Trump's attorney, Stephen Sadow, tried to supplement the record with an affidavit from a private investigator. They subpoenaed AT&T to get call and text records as well as location information of Wade's phone throughout 2021. Analyzing that data, the private investigator said there were at least 35 occasions when Wade likely visited Willis and at least 2 occasions where he apparently spent the night. And this was all before Wade and Willis testified their relationship began. Then on March 4th, co-defendant David Schaefer's attorneys filed a motion asking Judge McAfee to reopen the hearing and hear additional testimony. According to the attorneys, Cindy Yeager, co-chief deputy district attorney for the Cobb County District Attorney's Office, had numerous in-person conversations with Terrence Bradley about Willis and Wade's relationship. According to Yeager, Bradley told her in no uncertain terms that Willis and Wade's romantic relationship started while Willis was running for district attorney in 2019 and 2020, and that they used Robin Yurdy's condo prior to 2021. After watching Bradley's televised testimony, Yeager became concerned that Bradley's testimony was directly contradictory to what he told her, and she felt obligated to disclose what she knew.
Now, if I can interject for a moment, if you find yourself defending the propriety of your prosecution, you'd probably want a good lawyer. But if you want a great lawyer, my firm, the Eagle Team, can help. If you've suffered an injury or death in the family, got in a car crash, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are from the very beginning. So just click on the link in the description or call the number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. You can click on the link below.
Okay, let's all take a deep breath. Let's talk about the law of prosecutorial disqualification. Disqualification in Georgia can happen 2 ways. First, a prosecutor can acknowledge a disqualification at the outset. That's not uncommon, it happens. If the DA's son is the victim of a crime, that DA may just say, my office isn't going to handle this. Second, a defendant can file a motion and a court can then order that a prosecutor is disqualified. There's also the issue of scope. Sometimes it's enough to disqualify an individual prosecutor and remove them from the case. But sometimes an entire district attorney's office is disqualified. When an entire office is disqualified, the district attorney is required to notify the prosecuting attorney's counsel of the state of Georgia, and that counsel is tasked with finding a replacement. Now, judges can be disqualified too. Interestingly, the bar for disqualifying a judge is arguably lower than that for disqualifying a prosecutor. Judges are supposed to be neutral and unbiased in each case, avoiding even the appearance of impropriety. Prosecutors, on the other hand, aren't just allowed to be unbiased, it's literally in their job description. 100 years ago, the Georgia Court of Appeals said this: while the prosecuting officer should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and jury. The public prosecutor is necessarily a partisan in the case. If he were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals. But imagine I said all that in a good old boy accent. For a prosecutor, disqualification is only required under Georgia law when a personal interest is so strong that a prosecutor appears to be acting for his personal or individual interest rather than in his character as an officer of the law. There are two generally recognized grounds for disqualification of a prosecutor under Georgia law. First, a conflict of interest, and second, something called forensic misconduct. Forensic misconduct includes things like evidence tampering, but it would also include public statements by a prosecutor designed to prejudice a defendant in the minds of potential jurors, or a prosecutor injecting their own personal opinion about the guilt of a defendant during closing arguments. In this vein, Steve Sadow, Trump's attorney, alleged that Willis's speech at the church constituted forensic misconduct. A conflict of interest may arise when the prosecutor has acquired a personal interest or stake in the defendant's conviction. A conflict of interest requires more than a theoretical or speculative conflict. It has to be an actual conflict. And I'm about to bake your noodle. Actual does not really mean actual. An actual conflict just means that there's a strong possibility that conflict might arise. The stage is set, but the actors don't have to be on scene. The whole point of disqualifying someone when there's an actual conflict of interest is to prevent the conflict of interest from materializing in the first place. There are a few basic categories of conflicts of interest that have led to prosecutorial disqualification in Georgia in the past. First, and probably pretty obviously, there's usually a conflict of interest if a defense attorney switches sides and prosecutes his former client. Second, a prosecutor is disqualified if she's a fact witness against the defendant. Third, a prosecutor is disqualified if she has a close personal relationship with a victim. Fourth, and finally, a prosecutor can't have a personal financial stake in the outcome of the prosecution. For example, if a prosecutor is paid by a contingency arrangement, where they only get paid if there's a conviction, the prosecutor is disqualified because the fee arrangement creates at least the appearance of a conflict of interest between his public duty to seek justice and his private right to obtain compensation for his services. The unifying theme behind these categories is that a prosecutor must not seek a conviction for an improper purpose or using improper means. If a prosecutor could switch sides to prosecute a former client, for example, she would have inside information that could potentially violate the defendant's right to a fair process. Similarly, if the prosecutor has a financial interest in the conviction, then this conflicts with the prosecutor's duty to seek justice. If a prosecutor is a close personal friend to a victim, this conflicts with the prosecutor's duty to seek public justice rather than resolve a private vendetta. Now, this whole thing isn't the first time we've seen disqualification in this case. Willis and her entire office were disqualified from prosecuting Lieutenant Governor Burt Jones as part of the 2020 election conspiracy because the two had a political rivalry. When Jones moved to disqualify Willis, he was the target of a grand jury investigation into the facts of this case. Jones was serving as a state senator and was the Republican nominee for lieutenant governor. Willis had endorsed his opponent and held fundraisers for the Democratic candidate. Judge McBurney ruled that this was a clear conflict of interest warranting disqualification. Judge McBurney concluded that this choice, which the district attorney was within her rights to make, has consequences. She has bestowed her office's imprimatur upon Senator Jones's opponent, and since then, she has publicly, in her pleadings, labeled Senator Jones as a target of the grand jury's investigation. This scenario creates a plain and actual and untenable conflict. Any decision the district attorney makes about Senator Jones in connection with the grand jury's investigation is necessarily infected by it. Judge McBurney agreed that with respect to Senator Jones, Willis's prosecution looked suspect because any effort to treat Jones differently from other subjects of the investigation, even if justified, will prompt entirely reasonable concerns of politically motivated prosecution. Is Senator Jones being singled out because of a desire to further assist the Charlie Bailey campaign? The judge ruled that any investigation of Senator Jones would benefit Willis's preferred candidate, so she was disqualified from prosecuting him. But wait a second. How does that fit into the categories that have led to prosecutorial disqualification in the past in Georgia? Well, while it's not a financial stake, Judge McBurney clearly thought that Willis obtained some improper personal benefit from prosecuting Senator Jones. That's enough, according to Judge McBurney, for an actual conflict under Georgia law. But Judge McBurney also said something interesting in a footnote. A mere appearance of impropriety is generally not enough to support disqualification, except in the rarest of cases. This is one of those cases. Remember, kids, always read the footnotes, because in this case, Judge McAfee certainly did. You see, while the hearing was going on, the lawyers focused most of their time on details of Willis and Wade's relationship, from when it began to who was paying for what. Judge McAfee, though, seemed caught up in what standard he should be using to decide disqualification. Where does the appearance of impropriety fit in? In 2017, the Georgia Supreme Court addressed the issue of whether a district attorney should be disqualified in a murder case. In Battle v. State, the murder victim's mother was a longtime employee of the district attorney's office. When the defendant argued that the DA's office should have been disqualified on that basis, the court said this: "Certainly, a conflict of interest or the appearance of impropriety from a close personal relationship with the victim may be grounds for disqualification of a prosecutor. But here, there was no evidence that either the district attorney or the assistant district attorney directly prosecuting the case had any conflict of interest or a personal relationship with the victim or his mother, or any personal interest in obtaining the sought convictions." If you read that closely, it looks like the Georgia Supreme Court distinguishes two different grounds for disqualification: conflict of interest and the appearance of impropriety. And the court seems to view the relationship between the DA's office and the murder victim's mother as falling more under the appearance of impropriety category rather than a potential conflict of interest. And that's exactly how McAfee took it. McAfee issued his ruling on Friday, March 15th. He found that the defendants failed to meet their burden of proving that the district attorney acquired an actual conflict of interest in this case through her personal relationship and recurring travels with her lead prosecutor. McAfee noted that paying Wade by the billable hour is unexceptional and common in the legal profession, and also that the $250 per hour rate was relatively low for Atlanta given Wade's years of experience. Wade was limited to 60 hours of work per month unless he received permission to work more, and there's no evidence that Wade ever received such permission. And perhaps most importantly, McAfee pointed out that Wade wasn't Willis's first choice. She had offered the special prosecutor job to former Georgia Governor Roy Barnes first, but he declined.
I told D.A. Willis I'd lived with bodyguards for 4 years, and I didn't like it, and I wasn't going to live with bodyguards for the rest of my life.
McAfee spent numerous paragraphs in his order looking at Wade and Willis's travel and expenses. In the end, he concluded that there just wasn't enough evidence to say that Willis hired Wade in a kickback scheme, or that Willis was motivated to indict and prosecute the case because she had an interest in financial gain. Now, that's not to say that McAfee took Willis and Wade's reimbursement practice at face value. He acknowledged that the practice may be unusual and understandably concerning. Most damning, McAfee described the whole affair as a tremendous lapse in judgment, and described Willis's testimony as unprofessional. While he couldn't find an actual conflict of interest, McAfee pointedly said other forums or sources of authority, such as the General Assembly, the Georgia State Ethics Commission, the State Bar of Georgia, the Fulton County Board of Commissioners, or the voters of Fulton County, may offer feedback on any unanswered questions that linger. Ouch. Regarding Willis's church speech, McAfee did find that it was legally improper. According to him, the effect of this speech was to cast racial aspersions at an indicted defendant's decision to file the motion to disqualify. But the speech didn't rise to the level of forensic misconduct because it didn't specifically mention any defendant by name. It didn't disclose sensitive or confidential evidence, and it was too far removed to permanently taint the jury pool. That said, McAfee hinted that he might sign a gag order if the defendants were to ask for one. Now we get to the appearance of impropriety. McAfee pulled no punches. He excoriated Wade's patently unpersuasive explanation for the inaccurate interrogatories that he submitted in his divorce case. And he said a member of the public could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. Even though the defendants failed to prove Willis and Wade lied under oath, according to McAfee, an odor of mendacity remains, and there are reasonable questions about whether they testified untruthfully. All of that, according to McAfee, leads to a significant appearance of impropriety that infects the current structure of the prosecution team. McAfee then gave Willis two options. Either Wade goes, or you and your entire office do. Wade resigned hours later. So what does this mean for the Fulton County election interference case? Willis opted to have Wade resign, so her office is still prosecuting the case. If she hires another special prosecutor, it'll take some time to get that special prosecutor up to speed. But the big issue will be an appeal. Willis is unlikely to appeal McAfee's order since she wasn't disqualified. But the defendants can and most likely will try to appeal the order. It'll be up to Judge McAfee whether to allow an appeal right away or have it wait until after trial. McAfee would have to grant what's called a certificate of immediate review. If McAfee grants immediate review, that would start an appellate process that is really not well known for its speed. And that may be the whole point for some of the defendants, or let's be real, one specific defendant. Delay the trial until after the 2024 election.
Yeah, so everything looked terrible because it all looked incredibly stupid, but as Judge McAfee ruled, quote, in sum, the district attorney has not in any way acted in conformance with the theory that she arranged a financial scheme to enrich herself or endear herself to Wade by extending the duration of this prosecution or engaging in excessive litigation. So it's bad, but not disqualifyingly bad. Now, whether you believe Fani Willis about paying for her expenses in cash or not, we can all agree that it would have been way better for her budget to keep track of her expenses with today's sponsor, Rocket Money. Then at least she'd have some proof. Sometimes the sponsor segues just write themselves. Now, unlike Fani Willis, I never use cash, but recently I had a problem trying to get a handle on all my subscriptions. Between my personal and professional subscriptions, I was paying out almost $20,000 a year. Yeah, it turns out being an attorney is extremely expensive. Now, I hadn't been paying too much attention to what I was subscribed to, and once I started to track my expenses, it was insane how much money I was spending on monthly services I subscribed to a while ago and totally forgot about. But Rocket Money is an all-in-one finance platform that helps me be smarter about how I'm spending my money. It's a personal finance app that allows me to manage my subscriptions, lower my bills, and budget appropriately all in one place. And now that Mint.com is shutting down, it's a wonderful replacement. I'm currently using Rocket Money to help me cancel all the subscriptions I wasn't using for apps I didn't need anymore now that Succession is over. Plus, it told me recently that a service increased their price by $100 per year. I should really be looking into that instead of reading this ad. But Rocket Money has helped save its customers up to $740 a year with over $500 million in total canceled subscriptions. It does that in part by fighting for lower bills. You can simply upload a photo and tap a button, and Rocket Money will negotiate your bills for you, from internet service bills to cable and phone bills. So join the 5 million members using Rocket Money today. You can click on the link in the description or on screen to get started for free. You can also unlock even more features with premium. Again, just click on the link below to get started for free. After that, click on this link over here for more LegalEagle, or I'll see you in court.
But the word tariff is the most beautiful word in the dictionary, remember that.
Wow, so if we tariff the exports from other countries, they'll just pay us money with no downsides? Why didn't we try this before? Because that's not how tariffs work. And we have tried this before, and it might have caused the Great Depression. Just after the election, people suddenly started to search for how tariffs work and who pays for tariffs. The answer may surprise you, or it might be blindingly obvious. But can Trump install whatever tariffs he wants, and who pays for them? Chaos lawyer Liz Dye explains.
Thanks, Devin. Donald Trump has promised to slap 60% tariffs on all goods coming in from China and a 10% tariff on goods imported from all other countries. On the campaign trail, he even threatened to impose a whopping 100% tariff on auto imports from America's largest trading partner, Mexico. Before we talk about if he can legally do that or if it's a good idea, let's define our terms. The Center-Right Tax Foundation defines tariffs as taxes imposed by one country on goods imported from another country. Tariffs are effectively a tax on consumer goods paid by you and me and every other person who wants to buy stuff. So say that a Chinese manufacturer agrees to sell Nike a pair of shoes for $20. A 60% tariff means that the importer, that is Nike, pays $12 to the US government when those sneakers are offloaded from a cargo ship docked in Long Beach, California. Trump insists that the Chinese manufacturer is the one who ultimately pays for that tariff and that this will swell the U.S. government coffers with no impact on the American consumer whatsoever. But that's just wrong. The Chinese manufacturer is never going to eat the $12 tariff, and Nike doesn't want to reduce its net profit. So the end result is that the $12 tariff gets passed on to the American consumer at the point of sale, raising the wholesale price of that pair of sneakers by $12.
Yeah, if I can interject for a second, the problem is actually worse. You think, okay, a 60% tariff, so the consumer just ends up paying $12 more. Not great, but not terrible. But no, because sellers operate by gross margin. So if Nike imports a shoe for $20, they need to make a profit. But they aren't selling directly to the consumer. They need to sell the shoe to the retailer. And transport, advertising, and overhead is expensive. And doubling the manufacturing cost before selling it at wholesale would be totally normal. So let's say they sell it to Foot Locker for $40. But Foot Locker has to pay staff and operating costs in all their stores, which is expensive. So Foot Locker roughly doubles the wholesale cost of it again and ultimately sells the shoe to a consumer for $80. But that's in a tariffless world. A 60% tariff makes it $32 at import instead of $20, and $64 at wholesale, and then $128 at retail, assuming the same margins. So a $12 increase in tariffs on the cost of goods could easily result in a $48 increase in the final sales price that consumers pay. This is a simplification. In the real world, it would depend on the pricing power, and some of the costs would be shared between the parties, but you get the idea of how a small increase in cost of goods result in a much larger downstream cost to consumers. Plus, the domestic manufacturers don't just sit back while their foreign competitors raise their price. Why would they turn down free money when the consumer doesn't have any choice but to pay more? They raise their price to match or just undercut the foreign competition. Oh, and the cherry on top is that our foreign trading partners don't just sit back and take it either. They issue retaliatory tariffs against American exports, making them less competitive abroad. So people buy fewer American goods. And none of those taxes nor the original tariffs actually go to American companies. I don't know why people think this is boring.
In 1930, the Republican-controlled House of Representatives, in an effort to alleviate the effects of the, anyone? The Great Depression, raised tariffs. Did it work? Anyone?
If tariffs just make everything more expensive, why would we even want them? Well, in the early days of the Republic, we funded the government with tariffs on imports along with excise taxes on sinful products like alcohol and tobacco, which worked out more or less okay for about 100 years, especially for wealthy industrialists or the so-called robber barons who paid basically nothing to Uncle Sam. But in 1893, wheat prices crashed and an overexpansion of silver mines and railroads led to an economic bubble that burst. And even though the Great Depression hadn't happened yet, the Panic of 1893 ushered in the greatest depression that the country had ever seen, with unemployment rocketing to almost 20%. Imports dried up overnight, and no one had any money for alcohol and tobacco, which meant that the government had to go find some other source of funding. And that's how we wound up with a federal income tax instead of a pure consumption tax. In 1913, Congress ratified the 16th Amendment, which states the Congress shall have power to lay and collect taxes on incomes from whatever source derived. The U.S. government finally had a stable funding mechanism that wasn't directly tethered to the extreme ups and downs of the economy, and it was more fair. Because if you think about it, you only need one toothbrush, and Bill Gates only needs one toothbrush. But if the tax on a toothbrush is, say, 12 cents, well, that's a lot bigger share of your paycheck than it is of Bill Gates's. But Trump believes in cutting taxes on corporations and wealthy individuals, essentially returning us to the pre-16th Amendment days. In fact, the massive tax cut he rammed through during his first term is about to expire. Spoiler alert, it did not increase government revenues as promised, and now he wants to make those tax cuts permanent. So Trump has to find another source to make up for all the cash that will not be coming into the government coffers if he keeps cutting taxes for rich people. And that's yet another reason he's so invested in telling the lie that other countries pay import tariffs. In fact, it's a lie he's stretched to fit every occasion. Here he is in September explaining to the Economic Club of New York that the solution for skyrocketing childcare costs is, say it with us now, more tariffs. And you know what? We're going to let you listen to that entire 2-minute answer without any edits.
If you win in November, can you commit to prioritizing legislation to make childcare affordable? And if so, what specific piece of legislation will you advance?
Well, I would do that, and we're sitting down. You know, I was somebody, we had Senator Marco Rubio, and my daughter Ivanka was so impactful on that issue. It's a very important issue. But I think when you talk about the kind of numbers that I'm talking about, that because look, childcare is childcare. It's couldn't, there's something, you have to have it. In this country, you have to have it. But when you talk about those numbers compared to the kind of numbers that I'm talking about by taxing foreign nations at levels that they're not used to, but they'll get used to it very quickly. And it's not going to stop them from doing business with us, but they'll have a very substantial tax when they send product into our country. Those numbers are so much bigger than any numbers that we're talking about, including childcare, that it's going to take care. We're going to have, I look forward to having no deficits within a fairly short period of time, coupled with the reductions that I told you about on waste and fraud and all of the other things that are going on in our country. Because I have to stay with childcare. I want to stay with childcare, but those numbers are small relative to the kind of economic numbers that I'm talking about, including growth, but growth also headed up by what the plan is that I just told you about. We're going to be taking in trillions of dollars, and as much as child care is talked about as being expensive, it's relatively speaking not very expensive compared to the kind of numbers we'll be taking in. We're going to make this into an incredible country that can afford to take care of its people, and then we'll worry about the rest of the world. Let's help other people. But we're going to take care of our country first. This is about America first. It's about make America great again. We have to do it because right now we're a failing nation. So we'll take care of it. Thank you.
Now, sorry to interrupt, but if you're going to upend the entire economy, you'll probably want a good lawyer. But if you need a great lawyer, let my law firm, the Eagle Team, help. If you've suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, were involved in a car crash, or have dealt with sexual harassment, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away to maximize your recovery and find out what to do next. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So click below.
Trump's tariff math is also rooted in the claim that making it expensive to import goods from overseas will immediately revive American manufacturing. That idea is formally known as trade protectionism. That is, protecting local industries by making it more difficult or expensive to import goods from foreign competitors. That was the rationale behind the infamous Smoot-Hawley Tariff Act of 1930, named for Republican Senators Reed Smoot and Willis Hawley, and signed into law by Republican President Herbert Hoover, despite a petition from more than 1,000 economists warning him that it would blow up the U.S. economy.
Anyone? The Great Depression, the Hawley-Smoot Tariff Act.
The law imposed punishing tariffs of up to 59% on imported goods in an effort to protect American agriculture and industry. The tariffs are widely blamed for exacerbating the Great Depression, and they failed to curb unemployment, which continued to rise and remained high until the country entered World War II. They also wound up drastically decreasing the market for U.S. exports as other countries enacted retaliatory tariffs on American goods. Smoot and Hawley were both voted out of office in 1932, along with 10 other Republican senators, and Hoover lost to Franklin Roosevelt, winning just 6 states. And for roughly 75 years after that, conservatives opposed tariffs as a wasteful restraint on the free market, which is why the Tax Foundation says that tariffs are trade barriers that raise prices, reduce available quantities of goods and services for U.S. businesses and consumers, and create an economic burden on foreign exporters. Now, you may agree that propping up American manufacturing companies is a good idea. But you cannot escape from the simple math that tariffs are a tax levied on everyone in the form of higher prices for consumer goods for the purpose of ensuring that domestic industries won't have to compete head-to-head with foreign manufacturers, which is why Trump simply lies and says that it's a tax on foreign companies. Because if he said, under my plan, every non-food item at Target and Walmart is going to double in price, no one would vote for him. And okay, every country has tariffs. In fact, the U.S. has an incredibly complicated tariff system laid out in thousands of pages known as the Harmonized Tariff Schedule. How complicated? Well, here's an opinion letter from U.S. Customs and Border Protection to a costume company called Morph Suits, informing it that its Snake Eyes Ninja costume set should be classified as festive, carnival, or other entertainment articles, including magic tricks and practical joke articles, with 0 import duty. But the company's Captain Walker D. Plank set should be treated as other garments knitted or crocheted of man-made fibers, men or boys, with an import tariff of 14.9%. This distinction derives from a 2003 case called Ruby's Costume Company v. United States that differentiated between flimsy, non-durable garments that are essentially toys and well-made items that are functionally clothing. Like I said, complicated. But complicated isn't necessarily bad. Some problems just are complicated. And promising that you can simply wave a magic wand and fix those problems with one weird, simple economic trick is, it's a lie. Article 1, Section 8 of the Constitution says that Congress shall have the power to lay and collect taxes, duties, imposts, and excises, which certainly makes it sound like Congress has the power to impose tariffs. But over the years, Congress has delegated a lot of that power to the executive branch. Specifically, Section 232 of the Trade Expansion Act of 1962 grants the president authority to enact tariffs on essential imports relevant to national security. Section 232 was intended to give the president a tool to protect industries essential to fighting the Cold War. And Presidents Nixon, Ford, Carter, and Reagan all invoked that law to regulate oil production. But the Cold War is over, and no president has ever relied on 232 to justify a trade war, at least not until 2018, when Donald Trump invoked it to justify a 25% tariff on imported steel and a 10% tariff on imported aluminum. Both of these raw materials are indeed essential to national security, but they're not in short supply in the U.S. economy. China and the EU lodged complaints with the WTO about Trump's tariffs, alleging that they violated international free trade agreements. Essentially, they argued that the U.S. was cheating by pulling a fire alarm and calling something an emergency as a tool to extract a better deal. Trump himself admits that he uses tariffs as a bargaining tactic. He couldn't even be bothered to stick with the excuse that he was protecting American security the last time. At various points, he admitted that his levies against China were in retaliation for Chinese theft of American intellectual property. And when Canada protested the tariffs on steel, he responded that they were punishment for Canada's 270% tariffs on American dairy exports. For the record, Canada does not impose a 270% tariff on American dairy products. Initial WTO panels agreed in 2020 and in 2022 that the U.S. had violated free trade rules with respect to China, the EU, Norway, and Turkey. But the U.S. blocked the appointment of judges to the WTO appellate panel, kneecapping the institution and preventing it from reaching a final resolution on any trade dispute. And by the by, President Biden continued to block those judges, meaning that the WTO will remain functionally toothless for another 4 years. But what does a Section 232 trade war look like for normal Americans? Well, the last time around, Trump's Commerce Secretary Wilbur Ross, a billionaire steel magnate, went on CNBC holding up a beer and a can of soup he claimed to have just picked up at the 7-Eleven to assure Americans that they'd never even noticed the tariffs.
In the can of Campbell's soup, there's about 2.6 cents, 2.6 pennies worth of steel. So if that goes up by 25%, that's about 0.6 cents on the price of a can of Campbell's soup. So who in the world is going to be too bothered by 0.6 cents?
Somehow, Republicans in Congress were not convinced by Wilbur Ross cosplaying as Joe Sixpack, and they begged Trump to call it off. Canada immediately announced that it would enact dollar-for-dollar reciprocal tariffs on American exports of whiskey, orange juice, and other food products. Prime Minister Justin Trudeau called the tariffs
an affront to the long-standing security partnership between Canada and the United States, and in particular, an affront to the thousands of Canadians who have fought and died alongside their American brothers in arms.
The European Union, which is also our stalwart ally, announced tariffs on $3 billion of American exports, including Harley-Davidson motorcycles. The import duty on Harleys headed for the EU rocketed from 6% to 31%, massively cutting into the company's profit margin as the Europeans opted to buy their bikes from someone other than the U.S. The Peterson Institute for International Economics said you could not find a better case study than this episode of how the Trump administration's trade policy weakens American export competitiveness. Harley-Davidson responded to the crisis by moving some of its operations to Thailand, where it could export to the EU without the 31% tariff, after which Trump encouraged Americans to outright boycott this American company. In addition to the Trade Expansion Act, Trump invoked the International Emergency Economic Powers Act of 1977, commonly known as IEEPA, to justify imposing even more tariffs. In May of 2019, Trump claimed that undocumented immigrants at the southern border constituted an emergency that justified escalating sanctions on Mexico to force it to intercept migrants from Central America and send them back to their countries of origin. Citing IEEPA, he said Mexico's passive cooperation in allowing this mass incursion constitutes an emergency and extraordinary threat to the national security and economy of the United States. And he promised a 5% tariff on all goods imported from Mexico starting June 10, 2019, escalating by 5% a month until it reached 25% in October, where it would stay until the, quote, illegal migration crisis is alleviated. That would have been a disaster for both the US and Mexico, which is one of our biggest trading partners. Billions of dollars of goods move across the southern border every day in both directions. Plus, the timing of the announcement was especially awkward since the Trump administration had just finished hammering out the US-Mexico-Canada agreement, which replaced the North American Free Trade Agreement. Trump pulled us out of NAFTA, insisting that he could get us a much better deal. Republicans in Congress, who had been painstakingly negotiating USMCA with our biggest trading partner, hit the roof. Trump's own staff eventually talked him out of the Mexico tariffs. Instead, they let him go out on June 7th and announced that he was magnanimously relenting after extracting unspecified accommodations for Mexico with respect to the border. In fact, he'd gotten nothing new. His advisors simply talked him out of doing something that would massively damage the U.S. economy going into an election year. In the first Trump administration, the president took his cues from economics advisor Peter Navarro. Navarro was very big on starting a trade war with China, which is hardly surprising since Trump's son-in-law, Jared Kushner, picked Navarro by trawling through Amazon's page on economics and cold calling the guy who wrote such works as The Coming War with China and Death by China. Navarro is obsessed with the trade deficit, which is usually defined as the amount by which a country's imports exceed the value of its exports. Now, experts are divided on what trade deficits mean for a country's long-term economic health. But the reality is that the U.S. is a rich country, and we have spent most of the last 5 decades negotiating trade deals that allow us to buy vast quantities of cheap consumer goods from poorer countries where production costs are lower. We all decided that we wanted $5 t-shirts from Bangladesh and $300 flat-screen TVs from China or South Korea, 2 countries which buy a lot less stuff from us than we buy from them. And that's fine. It's not like you're running a trade deficit with a haircuttery. You made the decision that you'd rather pay someone else to cut your hair rather than have your mom put a bowl on your head and snip around it. And as someone who's had a home haircut can confirm, that's not economic warfare. But Trump and Navarro believe that other countries are somehow pulling a fast one on us if we buy more sneakers and Halloween costumes from them than they buy cars, soybeans, and Marvel Cinematic Universe movies from us. And so they cooked up a plan to make those countries pay for the dastardly crime of selling us stuff we wanted to buy. Trump promised that trade wars are good and easy to win. When we're down $100 billion with a certain country and they get cute, don't trade anymore. We win big. It's easy. But it wasn't easy. Trump's steel tariffs in 2018 failed to bring back steel jobs. According to the St. Louis Fed, there were about 82,000 steel workers in the U.S. when Trump took office, and the exact same number when he left. But the steel tariffs caused the inputs for car plants and construction to go through the roof and precipitated the loss of a reported 75,000 jobs in steel-dependent industries. After Trump imposed tariffs on washing machines, producers raised the price of washers by an average of $86. But they also raised the price of dryers, which were not under any new tariffs, by $92. Because in a capitalist economy, if the government says, hey, Samsung, how about we give you a perfect excuse to raise prices, the company's not going to look a gift horse in the mouth. So while those tariffs brought in an estimated $82 million annually for the U.S. Treasury, they wound up costing American consumers an extra $1.5 billion a year to wash and dry our clothes. And the thing about starting a trade war is that other countries tend to fight back. So in 2019, American agricultural exports to China cratered as China slapped its own tariffs on American exports and shifted to buying wheat from Canada and soybeans from Brazil. The U.S. government wound up handing out $28 billion to farmers to cover their losses in this easy-to-win trade war. And the tariffs didn't even lower the U.S.-China trade deficit, which climbed from $375 billion in 2017 to $418 billion in 2018. All of which is to say that Trump can promise all he wants that he'll easily bring back U.S. jobs by piling tariffs on China, but his own track record says otherwise. It's hard to know whether Trump really does intend to impose across-the-board tariffs on day one of his presidency, because so often what he means is that he's going to threaten to do something totally crazy and destructive, effectively flipping the board in the middle of the game, in hopes that whoever's on the other side will blink rather than find out if this madman really does intend to go nuclear. If he does intend to impose massive tariffs, he'll have IEEPA, the Trade Expansion Act, and several other congressional delegations of legal authority to rely on. Those laws were intended for use in wartime or actual emergencies and not as a bargaining chip to threaten other countries into changing the terms of deals we've already negotiated. But the language in the statutes is vague enough to give Trump legal cover to do more or less whatever he wants when it comes to tariffs. The National Retail Federation is warning that if Trump really does levy massive tariffs on China, it will raise the price of consumer goods by between $46 and $78 billion a year. When asked about the tariffs in an earnings call in October, the CEO of Black & Decker, Donald Allen Jr., said that the company had been planning for this possibility since the spring, and coming out of the gate, there will be price increases associated with tariffs that we put into the market. AutoZone CEO Philip Daniele said in September, "We know what the tariffs will be. We generally raise prices ahead of that." Neither executive contemplates shifting production to the U.S., as Trump has promised his supporters would happen. As the Black & Decker CEO told shareholders, onshoring to America is not cost-effective, and there's questions about whether we even have the labor to actually do that in this country. Both CEOs agreed that they were much more likely to relocate from China to other countries in Asia or potentially to Mexico if Trump starts another trade war with China. All of which may very well hurt China, but it will do nothing to bring down costs for American consumers or create manufacturing jobs here or increase government revenue. And in fact, the Tax Policy Center calculates that if Trump really does impose a 10% across-the-board tariff and a 60% tariff on China, it would lower the average after-tax incomes of U.S. households in 2025 by about $1,800 a year. So yes, legally speaking, Trump can enact any tariff he wants to at any time for any reason against any country. All he has to do is shout, "It's an emergency." But whether he should is another matter entirely.
Well, I'm actually happy to report that Trump's business advisors advised him against the tariffs, and he's listening to them and is backing down. No, I'm just kidding. Trump recently announced on Twitter that he is doubling down on tariffs and stated that he's going to issue a blanket 25% tariff on all imports coming in from Canada and Mexico, as well as institute an additional 10% tariff on all goods coming in from China. For drugs, I guess. It doesn't really make all that much sense. So if Trump does what he says, I guess we're completely tearing up the USMCA and basically every other trade agreement that we have. Now that might be a terrible idea, but the one thing you should definitely do is subscribe to today's sponsor, Nebula, where you can learn even more about tariffs from my fellow creators. Like Morning Brew Daily talking about how the world economy is bracing for tariffs, TLDR News talking about how Trump would transform the US economy, and Money and Macro talking about how this will create another trade war. Because on Nebula, you can watch all of our videos ad-free and early, because our videos always go up on Nebula first. Plus, there's tons of exclusive content, and for a limited time, you can get a lifetime membership. You can buy once and then never again. It's the greatest steal of all. And I know tens of thousands of you signed up for Nebula using the Curiosity Stream bundle, but unfortunately, that's over. So if you want to support this channel, the only way to ensure that the money you spend on Nebula goes to us is to sign up directly. And if you're new here, Nebula includes tons of exclusive videos from me, original series from your favorite people, movies, plays, classes, and more. I've heard it described as Netflix for people who like trains, with your favorites like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and obviously your most favorite, LegalEagle. And exclusives on Nebula are getting really good. Recently, I enjoyed watching RiffTrax's commentary over Plan 9 from Outer Space. It was the perfect video for Halloween. And how awesome is it that the RiffTrax and MST3K folks are on Nebula? And you can see my feature-length documentary, Bad Law Words Good, my other Nebula exclusive content, including my full-length interview with the screenwriter of My Cousin Vinny, and my Not Safe for Work video about lawsuits that are too hot for YouTube. Because what's truly special about Nebula is that it's a creator-owned platform built by me and other YouTubers and podcasters, and because it's a subscription service, we get to work on larger, higher-budget productions than we ever could anywhere else. It's becoming the answer to the question, how do you get Hollywood-level production value without Hollywood-level BS? And this holiday season, for those of you that want to share everything Nebula has to offer with your friends and family, Nebula is now offering annual gift cards. So if you sign up using the link that's on screen right now or down below, you can give a year of Nebula to a friend for 40% off the yearly subscription. That's a year of the best content for just $36. And it's a gift that you can give to yourself, by the way, because you deserve it. So get 40% off of you or a friend's yearly subscription for just $36 a year. That's $3 a month for all of your favorite content, or you can check out the lifetime deal where for $300, you can get access to Nebula for forever. Because we're investing in more big concept, high octane Nebula originals, and your lifetime subscription goes towards that investment. In a way, Lifetime is the best possible deal of all. But either way, you'll get LegalEagle videos early, get access to exclusives, and support the ambitious projects that my friends and I are working on our own streaming site. So sign up now and get you or a friend 40% off of Nebula at $36 a year, or get the incredible Lifetime deal by clicking on the link below. And after that, click on this box over here for more LegalEagle, or I'll see you in court. Trump has been gagged multiple times by the court. Yes, as soon as multiple gag orders had been issued, it seemed like Trump has violated them, and that's gonna be a whole thing. And I know we did a whole video on how Trump was claiming he was under a gag order when he wasn't. Well, now the gag orders are really coming down. U.S. District Judge Tanya Chutkan has heard enough, and after a 2-hour hearing about Donald Trump's habit of calling prosecutors and witnesses liars, thugs, and traitors, the judge has issued an order barring him from making any public statements targeting witnesses, lawyers, and court staff. Now, the order applies to all parties, but so far only one of them has been suggesting that some witness kinda sorta maybe should have been executed, and that person is Donald Trump. Judge Chutkan said Trump can, quote, assert his belief that this prosecution is politically motivated, but his, quote, First Amendment freedoms do not allow him to launch a pretrial smear campaign. So of course Trump quickly exercised his free speech rights and blasted the order.
I'll be the only politician in history that runs with a gag order where I'm not allowed to criticize people. Can you imagine this? Do you believe this? I'm not allowed to criticize people, so we'll see. We'll appeal it, and we'll see, but it's so unconstitutional.
Now, after the Justice Department indicted Trump in D.C., Trump vented on Truth Social, "If you go after me, I'm coming after you." Now, there are obviously many ways that you can interpret that statement. Trump did not identify anyone by name, nor was it even clear his comment was about the D.C. case. He could have been talking about any of the people on his enemies list, such as Barack Obama, Hillary Clinton, or the editors who dropped him from the Forbes 400 list. However, the government contends that Trump was obviously talking about the D.C. prosecution. Special counsel Jack Smith said Trump subsequently, quote, made good on his threat by making inflammatory comments about the case on an almost daily basis. For example, Trump described Judge Chutkan as a biased Trump-hating judge who deserves a filthy and crime-ridden district that is over 95% anti-Trump. He also posted derogatory things about Bill Barr and Mike Pence. So Smith filed a motion asking the court to stop Donald Trump from making public statements attacking the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Prosecutors said that, quote, Trump's relentless public posts marshaling anger and mistrust in the justice system have already influenced the public. For instance, on August 5th, 2023, police arrested Abigail Jo Schrei for making, quote, racist death threats to Judge Chutkan. The government also said that jurors are already fearful of blowback by angry Trump supporters, citing the criminal trial of Brandon Fellows, a Trump supporter who was at the Capitol on January 6th. You might recall that during the trial, the jury sent the court a note expressing concern that Fellows might have information about the identity of jurors. But naturally, Trump opposed the motion. He argued that a gag order would be a prior restraint on political speech that would violate his First Amendment rights. Quote, the Biden administration charged President Trump, the leading contender in the 2024 presidential election, for statements he made as president. Now, keenly aware that it is losing the race for 2024, the prosecution seeks to unconstitutionally silence President Trump's, but not President Biden's, political speech on pain of contempt. And Trump argued that the court has less draconian tools to ensure a fair trial, including a change of venue, postponement of the trial, extensive searching of prospective jurors, and sequestration of the jurors as well. Those are arguably less restrictive options than the blanket protective order. And Trump wasn't wrong. Americans have First Amendment rights to freedom of speech, and criminal defendants have a constitutional right to a fair trial. And you don't give up those rights even when you're accused of 90-something crimes.
I got 99 problems, but Judge ain't one. Hit me.
But there are scenarios where a person's right to a fair trial can be in conflict with someone else's free speech rights. If there is too much commentary about a case, it can taint the jury pool. Now, this is a fairly underdeveloped part of constitutional law because criminal defendants rarely have such a burning desire to make pre-trial statements, as well as the means to fight the court when they issue these types of orders. But the Supreme Court has held that judges can limit attorney speech when a lawyer's words have a substantial likelihood of materially prejudicing a legal proceeding. In Gentile versus State Bar of Nevada, the court said that attorneys aren't entitled to the same degree of protection as the media. But what if a person is making incendiary statements as a criminal defendant? Well, the Supreme Court has never explained which standard applies to the speech of a criminal defendant, let alone the standard that applies to a person running for president. In Trump's case, the government argued that the court should apply the standard articulated in Gentile versus State Bar of Nevada. Well, Trump argued that the Gentile standard only applies to lawyers. Trump contended any speech restrictions on defendants must survive strict scrutiny, meaning that the government must prove that any prohibited speech would constitute a clear and present danger to the administration of justice. At the hearing, Judge Chutkan announced that she would sidestep the issue of the proper standard. She said, quote, I intend for any order I issue to meet to satisfy either test. Now, as you can probably tell, Trump is going to need a good lawyer to fight all these gag orders. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, suffered a data breach, or were involved in a car crash, we can represent you or help find you the right attorney who can. Because getting a lawyer right away is so important to make sure you get a full recovery. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. Link is down below. Now back to all the gag orders. But different courts have different rules. In Trump's New York hush money case, Judge Juan Manuel Merkin issued a protective order preventing Trump from publicly discussing the evidence disclosed during the discovery process. The order also prevents Trump from receiving the names or other identifying information about people who work for prosecutor Alvin Bragg, other than prosecutors and law enforcement members, until the start of jury selection. However, Judge Merkin refused to characterize this as a gag order. He said he would not impose a gag order because, quote, such restraints are the most serious and least tolerable on First Amendment rights. That does apply doubly to Mr. Trump because he is a candidate for the presidency of the United States. In Merkin's view, the government would need to show that Trump's speech presented a clear and present danger before he would restrict it. In Trump's New York civil trial, Judge Arthur Engeron issued a limited gag order after Trump posted a photo of the judge's clerk with Chuck Schumer along with a link to her private Instagram profile. But Judge Engeron was not amused. He said, quote, consider the statement a gag order forbidding all parties from posting on social media about members of his staff. Judge Engeron did not limit Trump from speaking about the judge, though. In Washington, D.C., the local federal court rules are stricter. In order to avoid interfering with a fair trial or prejudicing the administration of justice, Rule 57.7 prohibits anyone from making a public statement about, quote, the identity, testimony, or credibility of prospective witnesses, and any opinion as to the accused guilt or innocence, or as to the merits of the case or the evidence in the case. If the case is a widely publicized or sensational criminal case, the court, on motion of either party or its own motion, may issue a special order governing such matters as extrajudicial statements by parties, witnesses, and attorneys likely to interfere with the rights of the accused to a fair trial by an impartial jury, the seating and conduct in the courtroom of spectators and news media representatives, the management and sequestration of jurors and witnesses, and other matters which the court may deem appropriate for inclusion in such an order. Trump ally Roger Stone ran afoul of this rule when he posted a photograph of Judge Amy Berman Jackson with crosshairs superimposed over her image. The judge said Stone was trying to, quote, gin up more public comment and controversy about the legitimacy of the Mueller investigation, the House investigation, and to get people to question the legitimacy of the prosecution. She concluded that Stone was acting in a manner that would pose a substantial likelihood of material prejudice. Now, the gag order hearing in front of Judge Chutkan went about as well as you might expect. The judge went through several of Trump's statements, asking both sides to comment about whether Trump's comments interfered with a fair trial or prejudiced the administration of justice or the credibility of witnesses. Judge Chutkan was most concerned about whether Trump's statements about the judicial system and its employees violated local rules. She said she was aware of and did not care about what Trump said about her, but she was appalled by Trump's comments about Judge Engeron's clerk. She wanted to know if John Lauro, Trump's attorney, agreed that such statements were out of bounds. Lauro said he would advise Trump that such comments were a bad idea, but he also argued that, quote, nothing has happened like that in this case, and nothing like that will happen. Judge Chutkan was skeptical. Lauro said there's no need for an order because when a judge or lawyer tells Trump to do something, he does it. Quote, because if Your Honor makes that kind of admonition, it will be followed, and it has been followed. Lauro really did say that, but without cameras in the courtroom, I don't know if he said that with his straight face. Judge Chutkan asked Lauro about the things that Trump said about Bill Barr and Mike Pence, and Trump posted a video attacking Barr for not helping him overturn the election and criticized Pence for not throwing out electoral votes.
Why does Fox News constantly put on slow-thinking and lethargic Bill Barr, who didn't have the courage or stamina to fight the radical left lunatics?
And she also wanted Lauro to address Trump's September 22nd comment about Joint Chiefs of Staff General Mark Milley. Trump said, quote, this guy turned out to be a woke train wreck who, if the fake news reporting is correct, was actually dealing with China to give them a heads up on thinking of the President of the United States. This is an act so egregious that in times gone by, the punishment would have been death. Lauro said that Trump's commentary about Milley, Pence, and Barr is acceptable because, quote, none of them have ever suggested that the criticism of President Trump has led to any diminution of their ability to do their jobs or testify or do whatever they want to do in terms of criticizing President Trump. Just the opposite, they give as good as they take. Judge Chutkan disagreed. Quote, that's right up to, would no one rid me of this meddlesome priest? If you suggest that someone is deserving of execution, that's not a far stretch to imagine a situation where one of the millions of followers of this person decides to go ahead and do that. Laura responded by saying she hit the nail on the head and brought up the time that a deranged Bernie Sanders supporter shot Steve Scalise, which really is not exactly the point that he was trying to make there. Lauro said that the gag order proposed by the government would mean that Trump couldn't truly campaign against Joe Biden, but even under the government's proposed order, the prosecutor conceded that Trump wouldn't be barred from attacking Joe Biden or Joe Biden's Justice Department. But the government didn't totally have its way during this hearing. The prosecution sought a very broad gag order that would have undermined Trump's ability to challenge the prosecutions as politically motivated. The DOJ wanted to bar Trump from making any derogatory statements about the Department of Justice or Merrick Garland. Judge Chutkan was reluctant to impose a restriction on Trump's ability to challenge his prosecution by the DOJ. Quote, "It seems awfully close to his right to assert his innocence and criticize the government." And the Supreme Court emphasized in Gentile that speech critical of the exercise of the state's power lies at the very center of the First Amendment. And while the government tried to persuade Judge Chutkan that Trump's attacks on the city would somehow prejudice the jury pool, she disagreed. Quote, "This is not about whether I like the language Mr. Trump uses. This is about language that presents a danger to the administration of justice." So after a 2-hour hearing on the motion, Judge Chutkan issued an order granting the motion in part and denying the motion in part. Quote, "In order to safeguard the integrity of the proceedings, it is necessary to impose certain restrictions on public statements by interested parties. Undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed." The judge found that Trump went beyond merely criticizing the judicial process. He crossed the line by stating that, quote, "Particular individuals involved in it are liars or thugs or deserve death." The court finds that such statements pose a significant and immediate risk that 1, witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats. 2, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. And that risk is largely irreversible in the age of the internet. Once an individual is publicly targeted, even revoking the offending statement may not abate the subsequent threats, harassment, or other intimidating effects during the pretrial as well as trial stages of this case. The judge rejected Trump's contention that the court can't limit his speech because he's running for president. Quote, "The bottom line is that equal justice under the law requires the equal treatment of criminal defendants. Defendants' presidential candidacy cannot excuse statements that would otherwise intolerably jeopardize these proceedings." And her order applies to all parties to the case, not just Donald Trump, though, in fairness, it's only going to affect one person. It limits that person or people from making public statements that target prosecutors, defense counsel, the court staff, and any reasonably foreseeable witnesses or the substance of their testimony. But the judge did allow criticism of herself. And accordingly, Judge Chutkan ordered, quote, "All interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target 1, the special counsel prosecuting this case or his staff, 2, defense counsel or their staff, 3, any of the court staff or other supporting personnel, or 4, any reasonably foreseeable witness or the substance of their testimony." Now, that is a gag order, but it's not a total gag order. Trump is not prohibited from maintaining his innocence, describing his prosecution as politically motivated, or criticizing the government. Now, if a judge finds the defendant has disobeyed an order of the court, the person can be found in criminal contempt. And criminal contempt can carry a penalty of days in jail, thousands of dollars in fines, or both. The court can also impose stricter orders and fines. A person in violation of a court's order can have their bail revoked, meaning that would put the person in custody until trial. That's what happened to Sam Bankman-Fried, who was under house arrest while awaiting trial. Prosecutors said that Bankman-Fried tried to intimidate former FTX CEO Caroline Ellison by publicly sharing her diaries. And he allegedly also tried to contact FTX General Counsel Ryan Miller over email and the encrypted messaging platform Signal, which violated the judge's conditions of release. So the judge in that case revoked his bail. But if you're anticipating that Trump would be put behind bars for violating any of these gag orders, you probably should lower your expectations. Given the circumstances of these cases, I wouldn't expect that to happen unless it was the most extreme of circumstances. And judges know that keeping Trump from making disparaging remarks is playing a game of whack-a-mole, but courts do have other options to coax him into compliance. For example, Judge Chutkan previously suggested that if Trump cannot follow the court's orders, she will bump up the March trial date. And it's likely that Trump doesn't want any of his trials to happen before the 2024 election. And at the hearing, John Lauro told Judge Chutkan that she could avoid the First Amendment issues by postponing the trial until after the general election. She brushed off that suggestion because it's probably the strongest tool she has to get Trump to comply. But of course, as soon as these gag orders were issued, it seems that they were violated. We're now getting a look at just how hard it is to coordinate a presidential campaign during a trial. On October 20th, the New York Attorney General alerted Judge Engoron that Trump had failed to remove a post about the judge's law clerk from his campaign website. Judge Engoron said, quote, "I learned that the subject offending post was never removed from donaldjtrump.com and in fact has been on the website for the past 17 days. Incendiary untruths can and have led to serious physical harm. I will now allow the defendant to explain why this should not end up with serious sanctions or I could possibly imprison him." He asked Trump lawyer Chris Kise why Trump shouldn't face serious sanctions, and Kise said it was just an accident. Trump had deleted the post from his social media accounts, but it was still on the campaign website. And after a brief recess, Trump's lawyers told the judge that nobody really saw the post. Trump's lawyers said that the campaign sent emails to roughly 25,000 recipients, but only around 6,700 of those messages were opened. But Judge Engoron was not amused. He fined Trump $5,000, but warned Trump not to do it again. Trump was, quote, way beyond the warning stage. But since Trump was a first-time offender, he felt that it was only appropriate to fine Trump a nominal amount. And Trump quickly gave Judge Engoron another opportunity to ramp up his fines. On the day Michael Cohen was testifying in the civil case, Trump offered these comments.
If we had a jury, it would have been fair, at least, even if it was a somewhat negative jury, because no negative jury would vote against it. But this judge will, because this judge is a very partisan judge, with a person who's very partisan sitting alongside of him.
When the judge found out about these remarks, he assumed they were directed at the judge's clerk, a clear violation of the order. Judge Engoron said, quote, it's very easy for the public to know who that person is. I'm very protective of my staff, as I believe I should be. I don't want anybody to be killed. And then the judge asked Trump's lawyers why there should not be severe sanctions for this blatant, dangerous disobeyal of a clear court order. Chris Kise said Trump was obviously talking about Michael Cohen, not the court clerk. Kise said that the context was that Cohen was partisan. This seemed dubious because Trump wasn't discussing the substance of Cohen's testimony and Cohen was not sitting next to him. It seemed clear Trump was referring to how the court was administering the case, that this is a bench trial instead of a jury trial, and that the judge and his clerk were Trump haters, and the clerk is the one that was sitting close to the judge. The judge tabled discussion of the matter until after the lunch break, when Trump agreed to take the witness stand where he was put under oath. Judge Engoron asked Trump who he was referring to, and Trump said, you and Cohen. The judge said, quote, first of all, my principal law clerk is very close to me. You and I can see each other, and we are close, but not as close. And there's a barrier between us, so wouldn't that at least be somewhat ambiguous as to whom you are referring? Trump didn't back off of his claim that he was referring to Cohen, which was probably smart on his part. But the judge said, quote, as the trier of fact, I find that the witness is not credible, and he fined Trump $10,000. Now, again, this fine is small in Trump's world, but the overall finding is a big deal. The judge, who's going to render a verdict in this case, found that Trump lied to his face. Other judges will probably take note, as will the special counsel. And speaking of Judge Chutkan's case, Trump appealed the gag order to the D.C. Circuit of Appeals, where he asked for an emergency stay pending appeal. Trump's lawyers also asked Judge Chutkan to stay her gag order while they prepared a full appeal, and Judge Chutkan issued an administrative stay of her own order. Now, the gist of Trump's appeal is that the order is unconstitutional because it limits his right to engage in core political speech. Trump argues that the part of the order restricting comments about Barr, Milley, and Pence is unconstitutional. Quote, the witnesses that third parties listening to President Trump have supposedly intimidated, former Vice President Pence, former Attorney General Barr, and former Chairman of the Joint Chiefs of Staff, Mark Milley, are extremely high-level public figures who have voluntarily entered the public arena and invited the cut and thrust of public debate by openly criticizing President Trump. Thus, the prosecution's speculation that these witnesses will be, quote, intimidated by President Trump's criticism is non-credible on its face. And Trump claims that the government should have produced affidavits from these witnesses attesting that they've faced intimidation and harassment. And these are not crazy arguments. Trump got support from the ACLU, which probably hasn't happened all that many times before, which filed a brief supporting Trump. Anthony Romero, director of the ACLU, said, quote, if we allow his free speech rights to be abridged, we know that other unpopular voices, even ones we agree with, will also be silenced. As much as we disagreed with Donald Trump's policies, everyone is entitled to the same First Amendment protections against gag orders that are too broad and too vague. The ACLU argues that the word targeting in the judge's order is also too vague. Quote, in the context of the order, it could mean something as innocuous as name or identify or something much more violent. One could target another with respectful but vigorous political advocacy, or target them for physical violence or death. The ACLU agreed that there is a serious risk that Trump's words can inspire other people to violence, but it contends that the mere fact that others have threatened actions against trial participants after hearing defendants' words is not enough. Of course, surprising no one, after Judge Chutkan stayed the order, Trump wasted no time in resuming his commentary on witnesses and prosecutors. Here he is describing Jack Smith as deranged in a way that would have violated the original order. In the same post, he attacked Anthony Pratt, an Australian businessman who says Trump shared classified information with him at Mar-a-Lago. And Trump also commented on Sidney Powell's guilty plea, clarifying that while she was never his attorney, she did a, quote, valiant job of representing a very unfairly treated and governmentally abused General Mike Flynn. Which is interesting because Powell took a plea deal and is now expected to offer testimony against Trump in the Fulton County case and could be a witness in the case that Judge Chutkan is presiding over in Washington, D.C. So Judge Chutkan has a conundrum on her hands. Trump's team will brief the court on freedom of speech issues and prosecutors will respond. But it's anyone's guess what will happen next. Judge Chutkan could invalidate the original gag order and issue a more narrowly tailored gag order, which could create a whole nother set of appeals, or maybe not, because it might be so narrowly tailored that it's not worth fighting over. Or she could let the original appeal play out. But Trump is wasting no time in issuing a ton of statements that probably violate the original now stayed gag order. Trump's comments include calling Jack Smith deranged. He comments on the substance of Mark Meadows' alleged testimony and has been lashing out at cooperating witnesses as weaklings and cowards. But Trump's gag order has been covered extensively by more than 190 different news outlets, and 29% of the reporting is coming from the left and 21% is coming from the right. And if you compare the headlines, you'll start to see some interesting frames emerge. On the left, you have outlets using terminology like imposed, ordered, and prohibits with reference to the gag order, while on the right, you'll find outlets using words like slapped with or hits. Those word changes are subtle, but they play a big role in how readers perceive the story. The first set of words might imply authority and precedent, while the second set of words might imply something unfair or immature. And all this is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. At Ground News, every story comes with a quick visual breakdown of the political bias, factuality, and ownership of these sources' reporting, all backed by ratings by 3 independent news monitoring organizations. I especially like the Ground News comparison feature, which highlights specific differences between left and right reporting. For the story on Trump's gag order, you can see the left-leaning outlets tend to focus on Trump's legal team opposing the gag order, while the right focuses on statements by Trump calling the indictments election interference and a witch hunt. Now, Ground News also has a blind spot feed, which highlights stories that are disproportionately covered by one side of the political spectrum. This kind of analysis is so important so we don't live in an echo chamber or get misled by subtle and sometimes not so subtle language in the news. So give Ground News a try by clicking on the link that's on screen right now. Ground News is giving LegalEagle viewers 30% off their Vantage plan. This includes access to a feature called My News Bias, which is basically a dashboard for your news diet. You can find out your top news sources, whether you're engaging with diverse perspectives, and what your favorite topics are. So you can try it out by going to ground.news/LegalEagle or click on the link that's on screen right now or down in the description. You can get started for less than $6 a month and support an independent news platform working to make the media landscape more transparent. And after that, click on this link over here for more LegalEagle, or I'll see you in court.
Just in time for the president's birthday, the royal family of Qatar has announced plans to give him, the U.S. government, a super luxury Boeing 747-8 jet. So put up your tray tables and fasten your safety belts, America, because it's time to meet the new Air Force One. Configured for commercial flights, the plane seats 600 passengers, but in its current blinged-out formation, the $400 million palace in the sky features 3 lounges, 2 bedrooms, 9 bathrooms, 5 galleys, a private office, and enough business-class seating to accommodate dozens of guests. Plus, it's got 5 55-inch TV monitors, 4 46-inch monitors, 1 40-inch monitor, and 1 32-inch, because you know the president likes to watch a lot of TV. The haters and losers are calling this blatant corruption. The president calls it a gimme.
When they give you a putt, you pick it up and you walk to the next hole and you say, thank you very much.
But even if it's technically possible for this aircraft to become the new Air Force One, and even if accepting it would save taxpayers money, this generous gift from a foreign oil-rich monarchy cannot possibly be legal, right? Well, in a word, no. But the Supreme Court has made it basically impossible for anyone to stop it. Thanks, Chief Justice Roberts. On the eve of Donald Trump's major foreign trip to the Middle East, ABC reported that the Trump administration was preparing to accept a luxury Boeing 747-8 from the Qatari royal family. Apparently, he toured it in February at the Palm Beach airport, and he liked it so much that they just gave it to him out of the goodness of their hearts.
He said, if I can help you, let me do that. And they had a plane. Not a new plane at all.
The plan is for the Defense Department to take possession and then retrofit the jet with the security and communication systems required to transport the president and his entourage. But only this president. In January of 2029, before Trump leaves office, the plane will be transferred to the Trump Presidential Library Foundation, which currently doesn't exist, but that's a problem for another day, as is the matter of what the next president is going to ride around in. Trump tweeted, "The fact that the Defense Department is getting a gift free of charge of a 747 747 aircraft to replace the 40-year-old Air Force One temporarily in a very public and transparent transaction so bothers the crooked Democrats that they insist that we pay top dollar for the plane. Anybody can do that. The Democrats are world-class losers, MAGA. The legal issues here are a lot. But let's start with the logistical ones, because Trump says he'll be flying around on Qatar Force One by the end of the year, and we have questions. According to the Air Force, the president's plane requires anti-missile countermeasures, including flare and chaff systems, nuclear electromagnetic pulse shielding, radar jammers, encryption systems with multiple layers of redundancy, and a whole bunch of top-secret military technology to operate as a nuclear command center while staying airborne for years, not days, in the event of nuclear war. You can't just bolt that stuff into the Love Blimp and head down to the Lido deck for a cocktail until it's time to rip it out again a couple years later. According to Kevin Buckley, a former Air Force official who oversaw the Air Force One replacement program, the aircraft would need to be torn down and rebuilt from the inside out, including overhauling electrical wiring, avionics, and power systems to install secure presidential communications, self-defense tech, and electromagnetic shielding. As one Defense Department source told the New York Times, we're talking years, not months. There's a reason why it's taken Boeing 9 years and counting to replace the 2 presidential planes the White House agreed to buy in Trump's first term. Boeing agreed to eat the cost overruns, and it's already $2.5 billion in the red on a $3.9 billion contract. That's why Trump was pissed and looking wistfully at the Qatari Royals ride, on top of which this plane is being gifted to us from a country Trump himself blockaded in 2017, accusing it of sponsoring terrorism, despite the fact that Qatar is home to a U.S. military base. That's a country that has every incentive to eavesdrop on the president and his advisors, or do worse. Experts are calling this a security nightmare. Republican Senator Shelley Moore Capito told CNN, "I'd be checking for bugs is what I'd be checking for," and even Senator Ted Cruz said this is a bad idea.
I also think that the plane poses significant espionage and surveillance problems, so we'll see how this issue plays out, but I certainly have concerns.
I can't believe you guys made me agree with Ted Cruz. Okay, so this plan seems wildly unfeasible. And since we've already bought the 2 replacement Air Force One planes from Boeing, it's not going to save us any money. In fact, it will cost us hundreds of millions of dollars to retrofit tacky Air One. But this is a law channel, so let's talk about the law. Can the president legally accept a $400 million plane from a foreign country? Article 1, Section 9 of the Constitution says no title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of Congress, accept of any present emolument, office, or title of any kind whatever from any king, prince, or foreign state. It's called the Foreign Emoluments Clause, and we also have a Domestic Emoluments Clause that bars the president from receiving any other emolument from the United States or any state beyond his fixed salary, because the framers of our Constitution were really serious about the president not profiting from his office. And that's why President Jimmy Carter had to give up his family peanut farm, because having a president get paid for peanuts would have been an ethical scandal. In his first term, Donald Trump at least pretended to divest from his company.
My 2 sons, who are right here, Don and Eric, are going to be running the company. They are going to be running it in a very professional manner. They're not going to discuss it with me.
But he still held on to his hotels and golf clubs, which became a magnet for companies and foreign governments that hoped to curry favor with the president. As one Asian diplomat told the Washington Post, "Why wouldn't I stay at his hotel blocks from the White House so I can tell the new president, I love your new hotel? Isn't it rude to come to his city and say, I am staying at your competitor?" Even before he was inaugurated, Saudi Arabia booked 500 nights at the Trump Hotel in D.C. They used the rooms to put up U.S. military veterans so they could lobby Congress against the Justice Against Sponsors of Terrorism Act, which authorized lawsuits by families of September 11th victims against Saudi Arabia. The Trump properties also benefited from a rash of ghost bookings, as foreign governments simply paid for blocks of rooms and never bothered to show up. All of this clearly violated the Foreign Emoluments Clause, and state governments filling Trump's pockets by conducting official business at his clubs violated the Domestic Emoluments Clause. The only question was who had the power to do something about it. During the first Trump term, there were 3 main Emoluments Clause cases. Competitors claiming they lost business because local and foreign tourists patronized Trump properties rather than theirs filed suit in New York and Maryland. and over 200 members of Congress sued, saying that Trump had usurped their authority to grant or withhold consent to a foreign emolument. Because remember, the Constitution says the president cannot accept gifts without the consent of the Congress. That case was filed in 2017 when Democrats did not have a majority in either house of Congress. So they could only sue in their individual capacities, and the D.C. Circuit said that they didn't have standing to sue as individual senators and representatives. Remember, standing is the right to come into court and vindicate some injury. And we don't know how that case would have come out if it was brought by the whole House of Representatives itself when the Democrats took it back in 2018. And look, maybe the Democrats will take back the House in 2026 and file a suit over the Qatari boondoggle. But the other two cases from Trump's first term give us a pretty good idea of how the Supreme Court would deal with it if they did. In those cases filed in New York and Maryland, the appeals courts, that is the Second and Fourth Circuits, found that the plaintiffs did have standing to sue because Trump was taking all those illegal emoluments and eating into their business. But thanks to Trump's stalling, by the time it got up to the Supreme Court, it was already the end of 2020, and Trump had lost the election to Joe Biden. So in December of 2020, Trump's Solicitor General Jeffrey Wall explicitly asked the Supreme Court to just run out the clock until Trump was out of office and then disappear the Second and Fourth Circuit decisions as moot. The technical term for this judicial three-step dance is a GVR, which stands for grant, vacate, and remand. Wall asked them to sit on Trump's petition to overturn the appeals court rulings until after Biden was inaugurated, then grant the petition and vacate the lower court rulings, essentially wiping away the Second and Fourth Circuit opinions, saying that Trump's competitors had standing to sue. And then the court could remand the cases to the lower courts with instructions to dismiss because they were moot once Trump was out of office. And that's exactly what they did. The Supreme Court's 6 conservative justices made sure there would be no precedent on the books that the president could be sued over the emoluments clause, which suggests that if the Democrats did take back one of the chambers of Congress in 2026, the Supreme Court would just let that case drag out until it was moot in 2029. Thanks again, Chief Justice Roberts.
Thank you again. Thank you again. Won't forget.
Between the emoluments cases and the immunity decision, the Supreme Court has signaled loud and clear that they're not going to hold the president to account. And so, this time around, Trump didn't even bother pretending to separate himself from his family business or claim that he wasn't going to do any foreign deals. His family already made $2.9 billion in just 3 months by trading in crypto coins. They just inked deals to build a hotel tower in Saudi Arabia and a luxury golf resort in Qatar. And by sheer coincidence, the U.S. just greenlit a $142 billion arms deal with Mohammed bin Salman, the head of the Saudi royal family. And of course, there's the other coincidence of the $400 million Sky Palace. But the Supreme Court has said that doesn't count as an emolument, or at least there's no one with the ability to do anything about it unless Congress decides to impeach the president. But could it be a bribe? Trump doing business with the Gulf states while accepting gifts from their leaders certainly has the whiff of bribery. Lucky for him, the Supreme Court has steadily narrowed the definition of public corruption, particularly 18 U.S.C. Section 201, that's federal bribery, and related statutes like the honest services fraud provision, that's 18 U.S.C. Section 1346, and the gratuity statute. In a 2016 case called McDonnell v. United States, the Supreme Court overturned the conviction of former Virginia Governor Bob McDonnell for honest services fraud. Essentially, that statute makes it a crime for public officials to steal the honest services they owe to their constituents by abusing their office. In this case, McDonnell accepted over $175,000 in gifts and loans from a guy named Jimmy Williams, who was hawking a dietary supplement called Anatablock. And if that sounds like the plot of a Simpsons episode, wait till you find out what was in it.
Tastes like cigarette butts.
Who gets tobacco? Ding, ding, ding. Anyway, Williams really wanted state research grants to study Anatablock, but McDonnell didn't explicitly make that part happen. Instead, he just introduced Williams around the Capitol and said what a great guy he was and conspicuously downed Anatablock pills during meetings with regulators and the like. And the Supreme Court said that there was no official act that McDonnell traded for all the cash that Williams gave him, so the conviction got tossed. The McDonnell decision really took the teeth out of the honest services fraud statute to the point that the DOJ didn't even bother charging New York Mayor Eric Adams under it when he got caught doing favors for the Turkish government. Then in 2024, the Roberts Court similarly narrowed the federal gratuity statute, which is 18 U.S.C. Section 666. In that case, the defendant, James Snyder, was the mayor of Portage, Indiana. He steered more than $1 million in city contracts to a local truck dealership, which later gave him $13,000 as a token of appreciation. In a 6-3 ruling, the majority held that the law does not criminalize after-the-fact gifts to state and local officials unless there's an explicit quid pro quo at the time of payment. Justice Kavanaugh wrote the majority opinion and is frankly bizarre. He said, gratuities are typically payments made to an official after an official act as a token of appreciation. Some gratuities can be problematic. Others are commonplace and might be innocuous. A family gives a holiday tip to the mail carrier. Parents send an end-of-year gift basket to their child's public school teacher. A college dean gives a college sweatshirt to a city council member who comes to speak at an event. A state legislator's neighbor drops off a bottle of wine to congratulate her for her work on a new law. So if you can give an apple to the teacher to say thanks, it's fine for a trucking company to give $13,000 in cash to the mayor of Portage, and it's fine for the Qatari royal family to give a $400 million jet to Donald Trump, just as long as the tip comes after the service or isn't directly connected to an official act. Oh, and while we're thanking the Supreme Court, we can add the immunity decision that the court's conservatives used to disappear the election interference case against Donald Trump in 2024. In that ruling, they said that the president could never be charged with an official act, and no evidence of official act could be used as evidence against him for any other crime. Justice Amy Coney Barrett pointed out that this would make it functionally impossible to charge the president with bribery, since anything he did would be an official act and inadmissible in court. Here, the very acceptance of the gift as head of state is probably an official act, and so this Supreme Court would probably exclude it from any future bribery prosecution. I mean, at this point, you can basically just leave it above my head permanently. The Trump administration has a variety of answers to its critics.
Of course, any donation to this government is always done in full compliance with the law.
Do you worry that if they give us something like this, they want something in return?
Absolutely not, because they know President Trump and they know he only works with the interests of the American public in mind.
Okay, Caroline. ABC reports that Attorney General Pam Bondi says the gift of this plane from the Qatari government does not violate the Emoluments Clause because it's not going to Trump personally, it's going to the government, or at least for a couple of years. She also says that it's perfectly fine to condition this gift on the U.S. government transferring the plane to the Trump Presidential Library Foundation on January 1, 2029. In fact, the agreement calls for the U.S. government to foot the bill to strip out all the military hardware and transfer the plane to the charity. And in another amazing coincidence, before she became the nation's chief law enforcement officer, Pam Bondi worked as a lobbyist for the Qatari government, which paid her $115,000 a month for her services. White House counsel David Warrington, a former lawyer for the Trump campaign, agrees that this deal is totally kosher. They also point to the fact that the Ronald Reagan Library houses an old version of Air Force One, which it has turned into an exhibit open to the public. But a decommissioned plane at the end of its useful life is a far cry from a modern plane which was recently renovated at a massive cost to the American taxpayer. And Trump is saying that he won't be flying on that plane after he leaves office, but he's been awful quiet about just what he intends his charity to do with a jumbo jet. Meanwhile, the president is yelling online that only a fool would turn down this wonderful gift from a country that wants to reward us for a job well done. Great. America is now hustling for tips, or at least the guy in charge is. Now, if it feels overwhelming that the president can just engage in open corruption when not 2 days prior his administration arrested the mayor of Newark on dubious charges, that's because it's supposed to feel overwhelming. And that's not just my speculation. You can hear it yourself from Trump's former chief strategist, Steve Bannon.
The opposition party is the media. And the media can only, because they're dumb and they're lazy, they can only focus on one thing at a time. I said, all we have to do is flood the zone. Every day we hit them with 3 things. They'll bite on one and we'll get all of our stuff done. Bang, bang, bang. These guys will never be able to recover.
That interview was in 2019, and they've had a lot of time since then to practice that grift. So while Trump is tweeting about his intention to openly violate the Constitution, the guy he appointed to run the Department of Health and Human Services, RFK Jr., you remember him, is hard at work in the background. Kennedy has already gutted the National Firefighter Cancer Registry, the Firefighter Fatality Investigation and Prevention Program, the Health Hazard Evaluation Program, the Respirator Approval Program, and the Coal Workers Health Surveillance Program, just to name a few. That's all a part of Kennedy's larger initiative called Make America Healthy Again, which is just a Trumpian way of saying that he's hell-bent on shifting the country's medical focus to pseudoscience. And that includes going after his ultimate nemesis, life-saving vaccines for children. I made an in-depth video on all of that, but we can't show it on YouTube without getting demonetized. Advertisers get a little jumpy when you start talking about dead children. But you can watch it and so much more by signing up with the sponsor of today's video, Nebula. And for a limited time, you can get a huge discount off a lifetime membership. You buy once, you get Nebula for life. In fact, we've been really active on Nebula this year with tons of Nebula exclusive videos like this video on unhinged judges or our analysis on the legality of using prison labor to fight wildfires. On Nebula, you can watch all of our videos ad-free and early because our videos always go up on Nebula first. But what truly makes Nebula the best place to watch LegalEagle content is that just about every video includes additional analysis and opinion that you won't get on YouTube. And make sure to check out tons of original videos from your favorite creators like Johnny Harris, Neo, Jetlag, Real Engineering, Real Life Lore, and hundreds more. And for those of you that want to share everything Nebula has to offer with your friends and family, Nebula is now offering annual gift cards. If you sign up using the link on screen right now, you can give a year of Nebula to a friend for 40% off the yearly subscription, a year of the best content for just $36. That's a gift you can give yourself, by the way. You deserve it. Or check out the lifetime subscription where $300 gets you Nebula for life. Nebula is growing fast and adding tons of new creators to the platform, so this offer is only available for a limited time. After that, click on this link over here for more LegalEagle, or we'll see you in court.
Man, can a guy take a vacation without something insane happening at the Oscars? As you probably know, Will Smith slapped the out of Chris Rock. As a lawyer, I have some thoughts about this. But first, let's look at the video.
You know who's got the hardest job tonight? Javier Bardem and his wife are both nominated. Now, if she loses, he can't win.
Okay, so the funny thing about the setup is that it's kind of pedestrian. He's poking fun at Javier Bardem and his wife, who he doesn't name, which he really should. And he's just kind of ribbing, creating fake marital strife. And of course, he's going to turn to Will and Jada in a second, but it's kind of a pedestrian setup. And like, the joke is there's fake strife there.
He is praying that Will Smith wins. Like, please, Lord. Jada, I love you. G.I. Jane 2, can't wait to see it. All right?
So here, Will Smith laughs, kind of a chuckle, not much. Jada's clearly not happy about that. Of course, the backstory here is that Jada Pinkett Smith suffers from alopecia, so she shaved her head because she was losing her hair. This is a medical condition, it is a disease, and of course, I'm sure she's incredibly self-conscious about it.
That was a nice one, okay.
And the crowd turns on Chris Rock. You can imagine another universe where the next day, basically Chris Rock gets canceled because he makes fun of Jada because of a medical condition, all for a stupid joke that's a callback to a movie that's 20 years old. And the audience hated it. Like, they were against Chris Rock, and he's like, that's just a gentle ribbing. And, true, it's not much. That's really mild as these kind of roasts go. And on top of it, the crowd was already against Rock. This is an insane setup for what happens next.
I'm out here.
Okay. So Will Smith gets up. Chris Rock here is just laughing because I think he thinks it's a bit. And also, this could be completely fake. It could be a made-up drama. They could have agreed to this ahead of time. We'll talk about the legal ramifications of that. But it looks genuine, like Chris Rock is going to engage in some colloquy with Will Smith as part of a bit, like making the joke, leaning into the joke. Of course, he leans in a different way. Boom.
Oh, wow.
Okay, so to me, that doesn't look like a punch. That looks like an open-fisted slap. He comes from below. He slaps Chris Rock across the face. You would think the guy who played Muhammad Ali, who trained like Muhammad Ali, Will Smith, would know how to throw a real punch. And I don't think that's what he's doing there. I don't think he's throwing a real punch. And we'll talk about the ramifications of this open-fisted slap.
Wow. Will Smith just smacked the out of me.
You gotta hand it to Chris Rock, though. Handles it like a pro. Is physically accosted and just rolls with it without missing a beat. I mean, I guess that's why he's Chris Rock.
Keep my wife's name out your mouth. Wow, dude.
Yes.
It was a G.I. Jane joke.
Keep my wife's
name out your mouth.
I'm going to, okay?
Man, you'd think there's got to be some past history here, and we'll talk about what that means. That doesn't seem like a normal reaction to a lame joke that's really modest, but he's clearly furious. That's very interesting that he's that angry. We'll see if that plays into the charges, the potential charges, and the potential defenses. But that is a really weird reaction. How often do you hear about people physically assaulting people for a mild dig like this?
Okay. That was a greatest night in the history of television. Okay.
And then Chris Rock tries to play it off with a joke. I would love to know if Chris Rock has ever been accosted in a comedy set. I mean, he's taken bigger shots at much more violent people, and yet here we are in the Oscars and Will Smith slaps him. And then, of course, Will Smith wins the Oscar for Best Actor. That's just insane. I'm actually surprised that the Academy went through with awarding it, given that in the past, people like Jeremy Clarkson have been fired from some of the most popular TV shows in the world. I'm kind of surprised that the Academy went through and gave Will Smith his award. He, of course, made a pseudo-apology during his acceptance speech. And in the past, Will Smith has talked about not wanting to be a vessel for violence and being a vessel for love. It is incredibly ironic that all of this happened at roughly exactly the same time. Just insane. Okay, so right off the bat, let's talk about whether this constitutes assault and battery. And obviously, it depends, because everything always depends. I'm just kidding. This is definitely assault and battery. Under California Penal Code 240, assault is the attempt to use violence against someone. It's not the actual physical violence itself, it is the attempt. Battery, on the other hand, is the actual physical touching and the physical force and violence against somebody else. Specifically, California Penal Code 242 defines battery as any willful or unlawful use of force or violence against the person of another. Now, you can be prosecuted for battery even if you don't cause any physical injury or pain. Really, all that's required is that you physically touch that person. And simple battery is a misdemeanor that carries with it a potential 6 months in jail, that's the maximum, and a $2,000 fine. Now, obviously, those maximums aren't dished out on the regular. Now, obviously here, since Chris Rock was able to continue with the set almost like nothing happened, you can understand that he didn't really suffer any long-lasting injury or pain. He just kind of rolled with it. But just because Chris Rock didn't suffer any demonstrable pain or injury, and obviously he felt pain when he was slapped, but it's probably no ongoing injury there, that doesn't mean that Will Smith cannot be prosecuted for assault and battery. Though by the same token, the fact that Will Smith did not use a closed-fisted punch with all of his might, that probably means that if potential charges came, they're not going to be the maximum. The police have better things to do than press these kind of charges. But you can imagine if he did punch Chris Rock Muhammad Ali style, that maybe that would convince the district attorney to move forward, and that might up the charges to something on the more severe end of the charges that you can bring, simply because it would have injured Chris Rock more. Now, this almost goes without saying, but I'm going to say it anyway. A lot of people have brought up the self-defense argument here. Defending your wife from hurtful words does not qualify as a justification for using self-defense or any kind of force against another person. Though if Chris Rock consented to it, that would defeat it. If Will Smith did agree ahead of time with Chris Rock to engage in this punch for the publicity or whatever, then that would mitigate any charges. Consent would be a defense to this kind of assault and battery. Additionally, some people are throwing around the First Amendment exception of fighting words. This definitely doesn't qualify as fighting words. Again, this is just a joke, a bad joke against another person. Basically, the whole words are violence crew on Twitter, very, very wrong in many different ways. There is no justification for using force against someone who just says mean things against you, at least no legal justification. And in fact, I actually found a California jury instruction, the law that is given to the jury in a case like this, that specifically says that words cannot give rise to violence. Specifically, the jury instructions say words, no matter how offensive, and acts that are not threatening are not enough to justify assault or battery. So fighting words, not applicable here. Now, that being said, a lot of different news sites are reporting that Chris Rock doesn't want to file charges, doesn't want to press charges against Will Smith. And as if that ends the inquiry. It actually doesn't. almost always, even if the victim decides not to press charges against someone, a district attorney can still move forward with the case. Now, there are certainly some pragmatic considerations that if the main witness who was the victim of a crime doesn't want to testify, well, then you're going to have a hard time proving your case. And a lot of people have said online that, if Chris Rock doesn't want to testify, there's no way that they can authenticate the video or, make the case. I guarantee if the police wanted to press these charges, they don't need to call Chris Rock. They could call anyone that was in the auditorium at the time. Those people could authenticate the videotape and they could testify as to their firsthand witnessing as to what happened. So that's to say that the normal considerations where the victim is the only witness to a crime don't apply here. There are hundreds, if not thousands, of witnesses who can not only testify to direct witnessing that they did, but can authenticate the videotape that was internationally broadcast around the world. But the bottom line here is that Will Smith started making trouble in his neighborhood. He got in one little fight. It's time that he move in with his auntie and uncle in Bel Air. Hopefully this video doesn't get demonetized because of the violence and the cursey words that were used throughout, but if it does, you should go watch an ad-free version of this video over on Nebula, where I have all of my exclusive content, including my first documentary, Bad Law Words Good, videos that are exclusive to Nebula, because I always have to worry about my content getting demonetized on YouTube. And in fact, now is a great time to get access to Nebula because we have an exclusive deal with CuriosityStream, which has some of the greatest documentary content on the internet. And you can get a bundle deal between CuriosityStream and Nebula where you get Nebula for free. So if you enjoy LegalEagle, if you would like exclusive content that you can't find anywhere else, bloopers, extended versions, new videos, my first long-form documentary, Bad Law Words Good, all of that content is available exclusively on Nebula, which you can get for free with CuriosityStream just by using the link that is on screen right now. There's simply no better deal in streaming right now. You get 2 great streaming platforms for less than $15 per year at the current sales price, and you'll actually watch that content. Plus, you'll be helping out educational content creators like myself. So click on the link that's on screen right now or down in the description to get both Nebula and CuriosityStream for less than $15 per day. And while you're there, click on this playlist over here with all of my other reactions to crazy legal things. Sometimes it's drama, sometimes it's the Oscars. So click on this link or I'll see you in court.